Good evening and welcome to Focus on Liberia. This is Dennis Jar and we're broadcasting from Atlanta, Georgia. Quite recently, elections were held in Liberia on October 10, 2017. The runoff was scheduled for November 7, 2017. In that process, there was an aggrieved party that was not satisfied with the election results and filed a complaint. They complained to the Elections Commission and then to the Supreme Court. Because of that complaint, the Supreme Court has recently filed a writ of prohibition stopping the Elections Commission from going forward with the runoff until investigations are completed. So, what really is the writ of prohibition that has been issued by the Supreme Court and what happened next? Tonight, we're going to discuss the Supreme Court ruling on the elections runoff and what happens next, all its implications and ramifications on the elections and going forward. To discuss this, I have invited some distinguished personalities in studio. In our community, we have Attorney Aaron Von Williamson. He's a lawyer and human rights activist, a former Liberian diplomat, a teacher, an author, and he's everything. Attorney, welcome to Focus on Liberia.
Thank you, Mr. Jai.
Also, I've invited a judge to dissect for us the Supreme Court ruling and all its ramifications. Our guest via video is Judge Melvin Johnson. Judge Johnson, welcome to Focus on Liberia.
Good evening, Brother John. Thank you for having me. Good evening to your viewing and listening audience. I look forward to this meaningful discussion.
Yeah, it's good that we have you. Briefly, I have with me in studio here Attorney Aaron Von Williamson, and I want both of you to discuss for me from the legal standpoint what all this means. So I start with you, Attorney Williamson. Just walk us through the Supreme Court ruling. What really happened?
Thank you, Mr. Ajah, and the producers and executive of this program. First of all, let me thank you for your patriotism and your nationalism. This is what we want to see more Liberian institutions develop, and I'm very much in awe of what you guys are doing, and I hope to participate in any aspect, any way, any shape and form as you may desire. The Supreme Court ruling on prohibition, as a petition was filed by the Liberty Party to enjoin or to stop the action of the Election Commission from proceeding with the runoff on, which was scheduled for November 7. Now, what the Liberty Party did is all provided for within Article 83B of the Constitution and Article 83C. So the Liberty Party is within the scope of law. It has the legal right to do what it did, filing a petition. Now, a writ of prohibition is what we call in law a peremptory writ. That is an immediate action. It's like, in simple English, run to the court immediately. The court, your honor, take serious action before a harm is done. So the petitioner is seeking a court order so as to avoid a harm or injury to a process or a violation of some fundamental rights of citizens that are aggrieved. So prohibition is an order. Now, it was a petition that was filed to execute a writ of prohibition, and which was succeeded which the Liberty Party did get a writ of prohibition, postponing the rerun. So basically, that's why the writ of prohibition is on. But it's a peremptory writ. That is, make it quick.
Right.
Your Honor, something got me happy. if you take action, something will happen. So, Your Honor, we the Liberty Party say, Supreme Court, you hurry up and take action because the Election Commission ready to violate our rights.
Right.
So that's what the whole prohibition is all about.
Thank you. And I'll bring you in, Judge Johnson. From the time the elections were held on October 10 to the day that the Supreme Court ruled putting a halt on the runoff, walk us through exactly what happened. What was the process that the Liberty Party followed and where we are today?
Again, thank you, Brother God. Let me just first take a moment and just praise God for the opportunity to still be counted amongst the living. You know, nowadays, anytime you can wake up and still be breathing, still be smiling, you have to say thank you, Jesus. Let me also extend my regards to Attorney, my colleague that just spoke so eloquently, as well as he so rightly said to the producers and executives. Thank you for this great forum that creates an opportunity for us to dialogue with our people. I think counsel hit the nail on the head when he said that the Liberty Party was within the confines of the Constitution. He's right. What they did was governed under Article 83 of the Constitution, which is in Chapter 8 of the Constitution. But walking through kind of what happened, Liberty Party basically is alleging, I think all of us kind of know, that there were irregularities and frauds that were perpetrated during the course of these proceedings, and they want the court basically to take action and look into it. And so let me kind of give some numbers here to kind of put us on track of how this thing works, because I know more than likely a lot of the listening audience are not jurists such as counsel and myself. So the elections were held on the 10th of October. Okay, the law provides that after the elections are held, if any party wishes to file a petition such as Liberty Party did, they have up to 30 days. They have up to the election commissioner have 15 days after the election to pronounce the decision. Any aggrieved party has 7 days thereafter the announcement to file anything they wish with the election commissioner. In this case, Liberty Party appeared to have filed with the election commissioner as well as with the Supreme Court, basically telling the Supreme Court that some things we believe had happened, some things we believe that we have outlined in our petition, and unless you address these things and address these things now, unless you halt the election process, we would not be able to get any other remedy. And so the court, after listening to that petition that was filed, agreed, issued the order saying, hold the elections, let NEC go ahead and conduct its investigation. All of that, again, is consistent with the Constitution.
We're going to go to phone if that is not corrected. So please check your audio. If not, you're going to be calling in so that we can have you on the phone. But let me go to you, Attorney Williamson. What exactly is Liberty Party complaining about in these elections for which the prohibition was issued?
Well, among many things is fraud, as stipulated in the complaint, the file a complaint indicating that there was massive fraud. Many people were not allowed to vote. Many people were denied the rights to vote, and so and so the fraud was massive to such an extent that the election should be the National Election Commission should conduct an investigation. Now, apparently, what happened was that the Election Commission was not seen as conducting an investigation, and the 30-day period was about to run. So that's why the Liberty Party said, "Hey, let me hurry up and go to the court," because had they stayed after the 30 days, they might have lost that right to file the appropriate rate. So massive fraud is alleged, and the Election Commission is that administrative agency created by the Constitution, autonomous agency created by the Constitution to investigate, conduct and investigate all elections, administer, conduct, investigate all aspects of the elections. So when she did not exercise her investigatory power, that's when Liberty Party proceeded to the court and requested for a writ of prohibition.
The Constitution provides for the Election Commission to conduct elections.
Yeah.
And if no one reaches 50 plus 1%, then we have runoff in 2 weeks or 15 days, 15 the second Tuesday.
Yeah.
All right. So the Election Commission is within the purview of the Constitution to do what it did. The Election Commission is also given 30 days to investigate.
Yeah.
So there is nothing in the Constitution that states that if there is complaint, you should stop elections until you investigate.
Well, again, they have in law we have what we call express and implied provisions of the law. Now there are certain provisions of the Constitution that are expressly stated, and there are certain provisions of the Constitution that are implicitly indicated for the fact that they say, for instance, a due process, must be held, must be exercised by all autonomous body.
Right.
Everybody, every institution is entitled to due process. Now, so a harm will be done if the runoff is being held and fraud have been discovered. So in that process, on the due process, the Election Commission was on a duty to investigate the complaint of the Liberty Party.
Let me bring you in, Judge Johnson, on this one. Say if runoff went ahead with the complaint pending because the Liberty Party or the Elections Commission had 30 days, it means that when runoffs are held, when the runoff is held and a winner is declared, after the investigation, the Supreme Court still has the right to overturn that decision. So, wasn't it within the legal framework of the Elections Commission to go ahead, no matter whether they have 10 or 20 cases? And even if there are cases, where do we draw the line as to which case will warrant the runoff being halted until that is investigated? Judge Johnson.
These are very good points you're making through your question, brother. It's sort of the chicken and the egg. In law, these situations come up all the time. This is what I mean. The Constitution, the law provides that after the election, NEC Election Commission has 15 days to go ahead and announce the results. Okay? Any party who is dissatisfied with that has 7 days within which to file any complaint with the Election Commission. Then they have 30 days thereafter to review that complaint and to either nullify the election as was held or to deny the complaint. Now, you rightly said they had 30 days. So NEC so far has not violated the law. They still were at least within the 30-day period. But the issue becomes when you file such a writ of prohibition to the Supreme Court, one of the qualifications for the writ is that a harm will be done that cannot be undone unless the Supreme Court steps in, which means Liberty Party basically convinced the court, which I think makes sense, that if you Supreme Court, allow the election commission to go ahead and have runoff and announce a decision, and then later on hear our complaint, if they hear our complaint and rule in our favor, much more potential chaos can arise versus if we stop everything temporarily, get everything straight, and then move forward. And so you're right, the election commissioners are within the bounds of the law because they still have 30 days to review it. But apparently, based on the petition filed by the Liberty Party, the court determined that yes, we need to step in now. We need not wait until a decision is rendered and then go ahead and try to undo that decision. In essence, when we created hope, when we basically allow NEC to notify a particular political party to start preparing for inauguration, we allow celebration that much could be anticipated would have occurred, and then we say, no, let's take it back from them. So in lieu of doing that, let's halt the process, let's get it right before we move forward. That's essentially what the court decided.
Judge Johnson, will you call this number 404-300-3925? Again, call 404-300-3925. Some of our viewers are not getting you that clearly. All right. So, Attorney Williamson, we come back to you on still on the issue of right now. This has been sent back to the NEC.
Yeah.
What is the NEC supposed to do now?
Well, it's supposed to conduct an investigation in keeping with the due process of law. Now the burden is upon he who alleges. Now, in this instance, it is the Liberty Party that alleges fraud. So, the Liberty Party will be required to bring all of the evidence to indicate the allegation of fraud. You know, and of course, the NEC has a quasi a judicial function. So it has its own attorneys.
Okay, yeah, hold on, Judge.
It has its own attorneys, and so it will be required. The commission will sit in a hearing, and where all the lawyers for Liberty Party, which is the petitioner, or in this case, yes, the petitioner, and the election commission will responding. They will bring all of the evidence during the investigation. Now, if the evidence are found to be true, and they are of the magnitude that it demands what they call a rerun, then the election has to be redone. If the evidence are not substantiated, then the election is upheld, and then we go to a rerun.
Well, now I understand the case was first sent to the NEC by the Liberty Party.
Yeah.
What happens before the Liberty Party went to the Supreme Court? Was it investigated? If not, why not?
Well, again, the Liberty Party, in the interest of time, you see, in law, timeliness of action is very important. It has 30 days. And these people, the Election Commission or NEC is seen as wasting time. So, in the wisdom of Liberty Party, say, let's hurry up. And the best way to go to the court is through the peremptory writ of prohibition. Make it quick, Your Honor, like I like to say. Make it quick. Our law, our rights are being violated. The Election Commission violating our rights. So we are depending on you, Supreme Court, in the interest of justice.
All right.
So that right is always, there are several parental rights. Habeas corpus, certiorari, injunction. All these rights are provided for so that immediate action can be taken so that the fundamental rights of individuals and institutions are not violated.
Thank you. Let me go to Judge Johnson on the phone. Yes, if you can, if you can repeat what you said earlier.
Can you lower your computer in the background, please?
And will you get an echo from you? Just lower your computer. Yes, sir.
Yeah, what I was saying earlier is that this is an issue that the Supreme Court, after listening to at least the evidence, what evidence is provided by the Liberty Party as a choice. People who might hear about what's going on and wish to criticize the jurors to the Supreme Court, this is the question the Supreme Court was faced with. And so those who might be critical of the Supreme Court, they should answer the question and tell us what's the alternative, what they would do alternatively. What the Supreme Court was faced with is a situation where the law says that an entity generally has 30 days after the petition is filed, to 30 days after the Liberty Party files a petition. Now, the law also provides that if there is an exigent situation, an emergency, as Attorney Williamson said, like a quick situation, then the court can also intervene. So the court was now put in a position, looking at the evidence that's presented by the Liberty Party of less fraud and massive fraud and providing it irregularity. The Supreme Court is put in a position of, do we wait until a winner is declared? Do we wait until a political party is notified that they have won the presidency of Liberia? Do we wait until we told these people to prepare for an inauguration? Do we wait until they start celebrating and then go ahead and do the investigation? And if we find that there is in fact massive fraud and irregularity as alleged by the Liberty Party, then do we spoil all of that party, all of that excitement, and potentially create chaos and destabilizing the country? Or do we take a break right now, carefully review all of these issues, sort them out for essentially a few weeks, and then make a decision that one of the laws would be clear and free of only $10 million, and then thereby declaring hopefully a winner going forward, and then the celebrations and so forth can go forward without any threat or potential of being halted. And the Supreme Court, I think, rightfully decided, after looking at the official evidence that was provided by LP, that let's halt this, let's get everything right, let's get everything on track, and then move forward. That way there will be less potential chaos, there will be less potential rioting and so forth in the street, because obviously an election is very important for our democracy, to the future of our country, and there are a lot of emotion, a lot of emotions and other things that are right important.
So, Judge, what happens after the Supreme Court, the NEC investigates and find that it has no magnitude for a rerun?
If I'm understanding you, you're saying what would happen after the NEC investigates and denies the Liberty Party's position? Is that what we're asking?
Correct.
Okay. After the NEC completes its investigation and should they deny Liberty Party's decision, Liberty Party will then have 7 days under Article 83, Chapter 8, Article 83 of the Constitution. Liberty Party will then have 7 days in which they can appeal the denial decision of the NEC to the Supreme Court. After Liberty Party, if they should appeal the negative decision to the Supreme Court within that 7-day period, then within that 7-day period, after the NEC is notified by the court that, hey, an appeal has been filed against the decision, NEC then will have another 7 days, basically, to present their documents of the court. So to summarize again, if NEC denies Liberty Party's decision, Liberty Party has a notification of the denial of 7 days while an appeal to the Supreme Court. 7 days after that appeal, within 7 days after that appeal is filed, NEC is notified. They now have to present this court to the Supreme Court, and the Supreme Court now has 7 days after those either confirming the NEC's decision or nullifying essentially the election and having a rerun, as my colleague Attorney Williams said.
You see, and yeah, 21 days, and meanwhile, Your Honor, January is coming closer, where there should be a constitutional transfer of power.
Right.
So there is it's very unnerving, and the population is on edge, given the history, the political, security, military history of the country.
Right.
So
And I was going to get to that, but
Yeah.
before we get to that, what if scenario? What are the merits and demerits of the Liberty Party case, if you may put on your lawyer hat?
well, the Liberty Party is squarely operating within the scope of law. It has the legal right and it has the constitutional support for its case, for the basis. It has a legal basis for the case. Okay, but there's something I learned in law, is that, well, not everything that is legal is expedient. You see, our country is in a very fragile situation. The Liberty Party has rights. No one is denying our rights. But in the interest of, and Councillor Bronski is not only an attorney, he's also a politician. He has lived and served the Liberian government in various capacities. President of the pro tempore of the Liberian Senate and now standard bearer of Liberty Party. The country still enjoys a fragile peace. And so is it politically expedient for us to run into an interim government? Because the Constitution provides that the president shall not serve longer than her term. She is required by chapter 6 of the Constitution, and says that is chapter 6, Article 50, which says that no person shall serve as president for more than 2 terms. So she's not allowed to even stay 1 more minute after her term. So then that creates a crisis. We have a vice president who also has the end of his term,
Yeah.
but he's running. He's a candidate. We have a speaker who is also a candidate. Now, so all of these people are legally incapacitated to be on the line of succession. and given Liberia's political history, interim government have not really served the people very well.
Right, but the line of succession continues to the pro tempore of the,
the pro tempore
and the ministers.
Again, there's so many things could happen. And given Liberian political history, they might just choose to suspend the constitution and set up an interim government, or they could choose to say, okay, let's have a pro temp. Or who should be the next in succession? Who is clear of all encumbrances? He doesn't have any baggage. So I mean that stops him from from being the line of succession.
Right. That's point. And let me come to you, Judge Johnson, because there is no crisis, so there will be no reason for an interim government. If for any reason we have that situation, we're going to go to Article 64 about the line of succession. Please comment on what happens if we don't have a president up to January 7, 2018.
Constitution is that it does not provide for a situation where the court essentially nullifies the election and then there's a succession that takes place. My reading of the Constitution, when it speaks of the succession, it speaks in a situation where the president is in the capacity, where the president is unable to help for other reasons to go forward. And also the Constitution also says, Representative Williams points out eloquently that the president cannot serve for more than 2 terms. And so he's both correct. Essentially, we have a similar drum. After where do we go from there? And I suppose that Representative Williams has said with regard to the history of Liberia, when we have an impasse, then transition into a place. But there's something that I think that many others are missing. We have processes in place, we have leaders in place that have been instructed to carry out the duty and we will not be here. And the work that should have been done has been done, okay? Just because you file a writ, a petition for probation for the Supreme Court doesn't mean it will be granted.
Yeah.
It has to have some merit. You have to present some evidence. You have to present to the Supreme Court that this is necessary. And so given that requirement, I'm under the assumption that the Liberty Party was able to present some level of evidence sufficient to convince the Supreme Court that the people who we entrusted to have one of the things that's been reported, that's one of the petitions, is that the Liberty Party is alleging that the president invited members of NEC to a private closed-door meeting at her house. That's just something that could not be done. That's something that cannot be done. And I just, for the life of me, I can't understand, given, again, our history, given that this is a pivotal election during the course of our history, how can the leader of our country, how can the other leaders, in fact, who have heard about this meeting, how could they have stood by and allowed this to happen? These are the things that make the situation we're in now. And so I just kind of wanted to comment on that because I'm hearing, I'm reading, I'm receiving reports from Liberia. People essentially are blaming the Supreme Court for making a decision when the Supreme Court did not create the problem. We're hearing a report of individual with, I think I was told, ballot machines or voter machines or something to that effect. And that individual has been the president's office or worked for the president, for the president's office. We hear a report of polling stations that have limitation of 500 that had tallies of exceeding 8,000 for one particular political party. If we as a people are to be concerned, to be upset with anybody that has created this problem, it is not the Supreme Court. They are trying to fix the problem. Yeah. The problem was created by the vacuum in our leadership, and I just don't mean the president, but the other leaders standing by, seeing all of this unfolding, doing
Judge Johnson, the meeting of the magistrates and some members of the election commission happened before the elections. That was before October 10. And there were some newspapers and other political parties that raised the issue. I don't remember the Liberia Party talking about that until after the fact. So if there were some issues of grave concern of that magnitude, don't you think that they were supposed to be reported prior to elections, then going into elections and afterwards saying, this is what happened prior to election and I'm not satisfied?
Yeah, no, I understand what you're saying. Again, the problem was not caused by the Liberty Party. We should be very careful to focus on the source of the problem and not the source of the attempted remedy to the problem. You see, so having this meeting that clearly is illegal, that is way out of bounds, is not the fault of the Liberty Party or the Supreme Court. And even at that time, the Liberty Party chooses not to speak up. All the other leaders, okay, all the other individuals who are concerned and now saying, oh, Liberty Party, you're stalling, you're threatening our democracy, they should have spoken up. They should have gone to the point. They should have filed something against the president. They should have filed something against NEC to say, look, this action will threaten our democracy. This action will create an appearance of impartiality. NEC don't only have an obligation to be impartial, but they have an obligation to avoid the appearance of being partial.
Yeah.
You see, and so you're right that perhaps Liberty Party could have and should have spoken up. Maybe they were busy campaigning or whatever the case is, but all the people who are concerned now that we have a problem, those people, those individuals should have spoken up. They should have gone to school. They should have rallied. They should have marched. They should have done something proactively. All I'm saying is that at this point, we should not be casting the blame on the individuals who are following the rule of law in an attempt to remedy a problem that has been created by leaders within our system. And again, I just don't mean the president. I mean the entire legislature. I mean all the leaders, the political leaders, even the civic leaders in our country.
Fair point. Thank you. And if you are watching us, this is Focus on Liberia. We are discussing the Supreme Court ruling on the elections in our country. I have Judge Melvin Johnson by video, and I have in studio Anthony Aaron Von Williamson. At this time, we're going to be taking a short break. And please, if you are watching us on Facebook, please prepare your questions and comments, or you can call us. The number is posted, 404-300-3925. That is 404-300-3925. Please stay tuned. We're going to be right back.
Knees on it, feel it. Accountability live, hip code network, yeah. We want peaceful election, yeah. We want peaceful election. Stop violence, don't cause problem. Hold hands for peaceful election. We want peaceful election. We want peaceful election. Knees on it. Stop violence, don't cause problem. Let's stand for peaceful election, yeah.
Welcome back to Focus on Liberia. We are discussing the Supreme Court ruling in the Liberian elections. So we're going to pick up where we left from, but if you're watching us by television or on Facebook, please call to join the conversation. The number is 770-904-9522. Again, the number is 770-904-9522. If you're on Facebook, please share your comments or questions, and we'll be happy to share them with our panelists. Anthony Williamson, we see that the Supreme Court, looking in this case, has so much power. Right. Just walk us through some civics lesson here. What really is the structure of the Supreme Court, and what is the power they have in this election to overturn basically everything?
The Supreme Court is the highest court of the land. All decisions rendered by the Supreme Court is final. as it relates to the election commission is more or less an administrative body, but then the Constitution provides that any investigation conducted by the election commissions and the parties, aggrieved parties, once they are dissatisfied, they take an appeal to the Supreme Court. Okay, that relates to the Supreme Court and the elections. So all through the elections law and the Constitution governing political parties and elections, the Supreme Court plays an important role. And it is that arbiter of justice, from for aggrieved parties coming from any form of political parties or independent candidate, or even common citizens. A citizen could file, a raid, to even enjoin it, or prohibit it, a prohibition because I never voted, and it's a constitutional right of every citizen to vote. So if for some reason I went to the ballot to cast my ballot and I got my voters registration card, and I could not exercise my franchise, I too can file a writ of prohibition.
Yeah. So we have three, and the Chief Justice is appointed by the President, even though they should be confirmed by the House, the Senate.
Yeah.
So just do a brief lesson now on the three branches, because they are separate. They're supposed to have power, but sometimes we find out that there is some form of, or maybe a perceived interference, that there is the Supreme Court looks like it's answerable to the President. It shouldn't be, right? So tell us about the three separate branches.
Well, the Constitution provides that the three branches are co-equal. No one has more power than the other. Now, but in our situation and in politically, the executive branch exercises a lot of authority. You might call soft power, because she makes all the appointments, and she controls the budget. And in a fragile democracy as ours, where the various political parties are not very potent, because right now Liberia should be a multi-party democracy, but most of the representatives are busy chasing after benefits, instead of the interests of the people. So if you have that system of government where there's check and balance, so there's not an effective check and balance on the executive. So the executive controls the judiciary. I mean, that's politically. So by default, we have co-equal power, but in practice, the president runs the show. I mean, you can see again for Liberian political culture, the president appoints the superintendents, she appoints the ambassadors, she appoints even the judges.
All right. Good. Let me go to Judge Johnson. And Judge Johnson is, Judge, please clarify too, you are a judge in America, not Liberia. So I want to make that distinction. So Judge Johnson, what is the history of cases like these going to the Supreme Court? And since our first multi-party elections, or the election that involved more than one candidate, was in 1855, when Hillary Arrow W. Johnson defeated Edward Bladden with 62 votes. Since that time, 62% of the votes. Since that time, what is the history of cases like these going to the Supreme Court, and what has been the trend?
Well, unfortunately, because of the war that we suffered, much of our records were lost, and they gathered some of them, they're gathering some of them. And so I wasn't able to research. And again, since I'm in the diaspora, my research, which is limited to electronic research,
Yeah.
I wasn't able to research and uncover electronically any legal precedent that that's what you're aiming at. But I do want to say something about what we talked about, what Councilor Williamson talked about earlier, about the separation of powers and powers that's given to the court and given to the president. I want to stress again to you all, to the hearing and listening audience, that our Constitution, our laws are sufficient. If every individual who is supposed to do his or her job, if they do their job, everything will work the way it is supposed to work. The Supreme Court did not file any petition. The Supreme Court is going about its normal course of business. It was only after leaders who were entrusted to do certain things, they failed to do those things. They deliberately did other things that they were not supposed to do. Hence, we have this issue. And so it is true, as Councilor alluded to earlier, that there is much power given to the executive branch. But again, the reason we're having this discussion, there is also much power also given to the judicial branch as well.
And Judge Johnson, is the Supreme Court, can any decision from the Supreme Court be appealed, could be rejected, or what happens to any decision? Can it be overturned? And by whom?
Yeah, the Supreme Court is the final, right? You have to have a final judge. You know, if we were to make the analogy to the home, you know, you have the children varying in ages, you have the mom, you have the dad, and so at some point, as they say in the West, the buck has to stop. And so the buck stops with the Supreme Court. When they make a decision, everybody has to abide by it. Everybody has to live with that decision. But again, the Supreme Court don't make decisions unless people do things they're not supposed to do or fail to do things that they're supposed to do. And another party comes to the Supreme Court and complains. But again, they are the final decision-making body, and once they decide, everybody has to abide by it.
But if I may add,
Right.
there are other processes we will call the process of judicial review, but where the court can in itself, you know, overturn its own decisions, you know. But the court is the final arbiter of justice, you know. But it's in its own self. I think you've heard about the process of judicial review, you know, where the court overturns decision. For instance, in the case of Dre Scott, where the Supreme Court ruled that, look, Dre Scott, when the American people were making the Constitution, their definition of people did not define black men as people. You know, but down the road, the same Supreme Court in the process of judicial review overturned that decision.
Yeah. It's good. Yeah. Okay. There were some cases that went to the Supreme Court because sometimes is how people perceive the Supreme Court. You know, the history of the Supreme Court dispensing justice blindly has been an issue as well. We found out that in the case of the 10-year residency clause of 2011, we saw the case involving the Code of Conduct of 2017. Where there was a case involving the elections in River G County 2014 was disputed that brought Senator Commonwealth Wizard to power was disputed by Jonathan Sobey or Bo Charles. So these cases went before the Supreme Court, and there were other cases that have been going before the Supreme Court. What is the history of our Supreme Court dispensing justice blindly?
Well, again, the Supreme Court has been a very fine court over the years, of course, but most of the rulings have been not on substantive issues, but on procedural matters. You know, on how the case was brought. Sometimes the court tries to evade the issue and then rely on procedure, how you file, when you file, and what you didn't do. You know, then they send it back instead of ruling on the merits of the case. So most of our case law, you will have a lot of procedural issues in there, and because again, the lawyers doing the stories were mostly apprentice lawyers, and so they already learned the civil procedure and criminal procedure. That's what they master most. They didn't learn the substantive issues of the law. So you see, but down the road, you know, in our legal development, you know, we have had some very fine lawyers, Chief Justice James A. Pierre, Chief Justice Louis Allegrams, you know, and the law school have been producing some fine lawyers as well. But the Supreme Court, in fact, has done a good job in dispensing justice. But again, justice it depends on the political philosophy of the justice who renders the opinion. Even here, you see why Democrats and Republicans always fighting over who to get to the court, right? Mm-hmm. Because they want the person who sits on our bench to have the same philosophy and the same values. I was going over the code of conduct the decision rendered by Justice Banks. And you know, another justice would have rendered it differently. And so because here, when I read the code of conduct and the case against Harrison Conway stated that emphatically that on March 9, 2007, that's when he turned in his resignation. You know, he which was what? So many just 6 months before the election. So clearly that was in violation of the code of conduct. Yeah. You see, but then they rely on one word, desire, and to change the whole outcome.
Oh, wow.
Yeah.
All right. If you are watching us, our number again is 770-904-9522. So you can join the conversation. Again, the number is 770-904-9522. Call that number to join the discussion. Now we have a caller on the line. Caller, your name and where you're calling from, please.
Caller, go ahead. Hello? Yeah, go ahead. Your name and where you're calling from. Go ahead.
Something interesting came up in regards to the trend of the kids of health. One of the issues that I've looked at from 2005 to 2011 is the fact that we all acknowledge that we have systemic issues one can equate to irregularities. And so we had irregularities in 2005. We had the irregularities in 2011, and some of us were hoping that the administration in conjunction or in collaboration with some of the political parties who have come together and you know, and try to guide on ways to actually take some of these issues. When you look at the transporting of violence to rivers, you know, you can blame that on the lack of roads, vehicles can actually go. But I've just said from day one that I think Democratic Party has an institution of failure or systemic challenges that they're trying to put to forward. And the only theory that there's something interesting came up. The Democratic Party, the Party chairman, who was the witness on the case, was talking about the fact that his name was not on the ballot. Now, the left came up with a left in collaboration with the political party said that if any name is not on the final row of the ballot, that individual should not be allowed to vote. the attorney representing the National Election Commission asked the witness, who happens to be the chairman of the Unity Party, a very interesting question, which was, he said, well, if the name was not on the ballot, then how did you vote? And he explained how he voted, and his explanation struck me. He basically said, well, after the representative from that looked at his voter registration card and recognized that his name was not on the list, the gentleman went and wrote his name down and said, you know what, we're going to write your name down and we're going to allow you to vote as well. And then the attorney asked the question to the witness. The attorney said, well, so are you confirming that you participated or you engaged in an illegal process? And so, you know, I was kind of shocked. I thought that was a tough question, because if these guys who are political, who manage political institutions, are complaining about irregularities, which I think that's all it is, are complaining about these systemic challenges, these issues that we face in our country, and they are facilitating the process or engaging in these process. How do you explain that from a legal perspective? Because if you are complaining about irregularities and the system is flawed, and you are participating in a system that goes against everything of the election laws, then how sure are your kids? How do you explain that?
Thank you. Thank you, Robert, and thank you for taking your time to call in. And Councillor Anthony Williamson, there was what Robert is saying. First of all, he said there was irregularities in 2005 and irregularities in 2011, and political parties did not come together to file anything, but that's passed. Now we have a situation where during the case he said he watched an official saying that he voted although his name was not on the ballot. So he's talking double standard here.
Yeah. Well, that's not a unique situation for the society we find ourselves in. The former United States government, President Obama obviously used to say, do not make perfect the enemy of good. And we have a whole lot to do in our country to make our political system whole. But meanwhile, we have illiteracy problem, we have semi-illiteracy problem, we have even our high school graduates, are graduating that can't even write a good sentence. And some of these people were pollsters, were election monitors, and they were expected to help our illiterate brothers and sisters, or mothers and fathers. And they couldn't help their hearing. And so we have all of these systemic problems, like Mr. Gagwa mentioned eloquently. And so this is why we are fighting to develop and sustain a political institution. It's not perfect, but we're trying to first get a good system. And this is why, again, I'm of the view that a Councillor Bronskin should look at this whole thing holistically and not only legally. You see, 'cause he as a politician knows the country. Okay, for instance, who sponsored the election? Who paid for the election? It was not the government of Liberia that paid for the election.
Right. All right.
Okay.
Thank you.
Go ahead.
And we have another caller on the line. And Judge Johnson, please stand by. There's a caller on the line.
Go ahead, caller. Go ahead. Yes, go ahead. Yes, Judge on the line. He's listening to you. Go ahead.
Who's that? Nathan? Oh, Sabwood. Correct. All right. Thank you. His name again?
Call your name. Where you calling from again?
All right. Thank you, Prince. And you were reacting to exactly what Attorney Aaron Von Williamson said. So, Aaron Von Williamson, can you clarify and talk to our colleague from Tennessee?
Well, basically, I was mentioning in passing the ruling of the Supreme Court with regards to the Harrison Conway case, Liberty Party, in which the issue of desire, the word desire was the most contentious word there, and in which Mr. Conway was saying that he could not desire to be vice president at the time. But the Code of Conduct did not specifically say the vice president. It said any elected office. Okay, but then Conway narrowed it to vice president, and the court sided with him. So I'm saying that what I was saying, a different justice will have ruled differently. And I was just mentioning that most of the judges that are on the bench, they are human beings. They have their own political values, they have their moral values, they have the principles. So they carry on these principles in the dispensation of justice. And that's why I said that we have a Republican always try to have conservative judges, and the Democrat always want to have liberal judges. That was in that context I spoke.
Okay.
We can make that argument.
Right. That's fair point. That's an argument. Judge Johnson, let me bring you in on this.
Good evening again to the caller, Brother Williams. I think he said his name was Prince Williams from Tennessee. Thank you for participating in the process. I tend to agree with the caller. I think the real problem here well, let me say it this way. I think oftentimes we fail to focus on the source of the problem. We focus on those individuals who are trying to remedy the problem, and we begin to point fingers and begin to try to judge and superimpose different views and things of that nature on the people. When we speak of the code of conduct issue, the problem was that people who we trusted, people who we paid to do a job, failed to adequately do the job. Okay, they failed to draft it properly. We have sufficient jurists in Liberia. We all know we have sufficient people with many degrees and titles and honorables and all of that stuff. They are entrusted to do a job. They need to do the job and do the job right. And they fail to do the job. And the court now is the one who has to come in and try to figure out a solution. And many of our people, we get upset with the court and so forth. So to some extent, I tend to agree with Paul Williams that, yeah, one word, one phrase can make a difference. But that's why we have all these honorables and all these doctors and all these lawyers and all these counselors and all these people to do the job, and they fail to do the job. Let me just say also, we have a good system in Liberia. We have a good system on paper, but the problem, one of the problems we have is taking that system off of paper, off of theory, and getting people to do their job. Getting people to train those people who are less sophisticated or less educated, or as Councilor Williamson says, we have the literacy issues. But with all due respect, the pollsters, people working during the election, I don't think they needed to have college degrees. I don't think they needed to be doctors in the university, counselors, and honorables, and so forth. I think simple systems, simple protocols that have been put in place. These people should have gone through exercises to know exactly what to do, and they should have done it. So again, we have individuals who do the job that fail to do the job. After they mess up, people are not pointing the fingers at them. People are not focusing on the mess up. People begin now to focus on those who are trying to fix the mess up.
Judge Johnson, what I keep hearing about is a phrase that is being thrown around is constitutional crisis. Are we headed towards a constitutional crisis?
Crisis. I say we're not heading for a constitutional crisis. I say we've had leadership crisis. We've had leaders, again, who have failed us. We've had leaders who have not done their job. When you say a constitutional crisis, normally you're referring to some kind of conundrum that has been created perhaps by inconsistencies in the Constitution or things in the Constitution that have come that have brought the situation to a halt. That isn't the case, my brethren. The Constitution is very clear. This Constitution we're referring to has been since 1847 and then more recently 1986. When you go back from 1986 to now, that document hasn't changed. It's been clear. So we've had no crisis with the document. We've had no crisis with the Constitution. We don't have a crisis now. We have a crisis of leadership. We have a crisis of people we've entrusted to do a job that have failed to do a job.
Thank you.
One of my prayers, as a people, we can rise to a point where we can hold our leaders accountable to do the job we put them there to do. Just do your job.
All right.
We don't have a constitutional crisis. We have failed leadership crisis. And I'm not merely referring to the president, but also to the legislatures and others that have the responsibility that could have stepped in before this failed leadership crisis got to this point, and they did not do that.
Well,
all right.
Thank you, Your Honor. But here are the constitutional crisis. Come January, when Madam Salif should turn over power, and we have not conducted the rerun, it becomes a constitutional crisis.
Then what happens?
Thank you. So that crisis now will determine various competing interests will be saying, oh, okay, let's have the succession. Others will say, oh, okay, no, the succession cannot hold. let's have an interim government. And so a crisis, it was certainly seriously present a constitutional crisis for such a fragile republic as we have. So I know, Your Honor, you are of the fact that there's a leadership problem, and yes, we know that, and that's why elections are held, to change leadership after the terms. Now, but in our situation, we don't have a perfect system. We don't have perfect institutions. So to hold our institutions to perfection, I think it's unfair.
All right.
Yes, thank you.
Judge Johnson, let me come to you on this one. Let's say a rerun is being ordered. What would a rerun look like? Are we looking at both the president, vice president, and the representative going for re-election? Who pays for it? People that were not 18 prior to October 10, 2017, they're going to be 18 now. Will there be re-registration? How will a complete rerun look like?
Would basically set the perimeters based on their ruling. More than likely, all those who were otherwise previously eligible, previously speaking to a continuation of time, looking back, all of those who otherwise were eligible will more than likely be the ones that participate. Now, what I think should happen, which probably more than likely is not going to happen, when you talk about the costs and who's responsible basically for all of this, I think those people who caused the problem, I think the law should deal with those individuals. It should deal with those individuals to find a way to get these individuals to contribute to the restoration of the problem that is caused, but also should deal with those individuals in a way that would deter others from doing such a thing going forward. But in terms of how a possible rerun would look, the Supreme Court would set the bounds for that. It will likely only include those voters who have previously registered, and so other people who have now become otherwise qualified due to the passage of time. I don't believe that the Supreme Court will allow new voters basically to be put in the pool. I think the pool hopefully will be utilized.
But will it include the representatives as well?
It likely would. It likely would, because the petition, which is the beginning of all of this, right? The petition as filed does not just point to irregularity. Well, I'm sorry. The petition does just point to the election that was held on October 10th. And so the petition does not specify and say, well, the irregularities were only specifically geared to this party or that party and so forth. But the petition points to irregularity and massive fraud. The petition alleges these things that were conducted during that election process. And so, the fruit of the poisonous tree is part of the tree, right? And so any fruit that came out of that election process, should the Supreme Court deem that the fruit is poisonous, then the Supreme Court will throw out not just the fruit, but they will be obligated to throw out the entire tree as well. And so when we talk about a crisis, this is the crisis that our leadership have caused. It's not a crisis that has been caused by the Constitution. The Constitution is the document put in place to govern our actions, but because our leadership failed to do what it was supposed to do,
okay, Judge.
This problem.
Judge, hold on 1 second. We have our last caller on the line, and we almost out of time. Patrick. Call out your name and where you calling from.
My name is Prince Williams, and I'm calling from United States, Johnson City, Tennessee.
Go ahead with your question or comment, sir.
Yeah, my comment would be on the concern about possible constitutional crisis. I don't think we will have a constitutional crisis, because the Constitution spells it all right in terms of the line of succession But all we will have, and all we have is projecting to have is just a judicial a test of our constitution to know if we have, if Liberian can be able to be tolerant to accept the unprecedented judicial circumstance that may before the Liberian transitional process
Thank you.
of leadership. But other than that, we will not have a constitutional crisis because we have a unique line of succession is written within the Constitution, and we can build on that and carry out the continuity of our government based on what our Constitution defines.
Well,
Okay.
in brief, let me just say in brief. If we do not have a president on January, then is a constitutional crisis.
Okay. Prince William, please just summarize briefly. We are out of time.
Yeah, the reason I say that in disagreement with the constitutional crisis, or crisis is defined, it won't be a constitutional crisis because the Constitution states it stated clearly in case the president or the government cannot be in continuity. So we have the speaker, we have the other officers, all that can succeed and hold or call for a special election. And I agree with John Johnson. We cannot let people who cause this crisis to go for impunity. These people have to be held responsible.
Thank you.
It's not a mistaken thing. It was something done intentionally, but we have to rectify it by the judicial process and allow the law to take its course. And I appreciate what the Supreme Court is doing.
Thank you.
guys very much.
Thank you so much. We have a comment on Facebook from Sir Rachel Bully and Attorney Rachel. Sorry that you said you have not been able to get through, but here's what he's saying. Frankly, this is going to be a long process. As a matter of fact, I can safely say that this matter is going to go back to the Supreme Court and maybe back and forth. All we can hope for is that God guides those judges to do the right thing as it is with the case and with the petitioners, that is the political party. Thankfully, we are now using the recourse of the law. It is going to be a long haul. Anything is possible. That's not satisfying enough. And we have one more on Facebook. Twali T. Man Doman. JMJ is totally wrong. I don't know who JMJ is. Oh, Judge Melvin Johnson is totally wrong about this statement on whether those who didn't vote because they were not of voting age during the first election. If there is no constitutional crisis, those that are of voting age should be allowed to vote. Okay, thank you very much for your comments. I think what the judge was saying was the Constitution or the Supreme Court is going to set all those parameters if and only if we are having a rerun. But we are almost out of time, and so I will go back to Judge Melvin Johnson for his final comments, and if he can summarize briefly what our last callers and comments have spoken to.
Thank you to Attorney Williamson.
September, okay? And when you had
do their job. They hold them to do that job. And I think we need to focus more on that. And I think if we do, we would have a much clearer path going forward. Again, thank you, Brother Todd. Thank you, Attorney Williamson. Thank you to the executives and producers of the show for having me on. It's been a great time deliberating this important issue. Let me just say, praise God again, and that God is good all the time, and all the time God is good.
Thank you, Judge Johnson. And before I go to Attorney Williamson for his final comments, and one question I'm going to ask you is whether any of these for Supreme Court, if they have term limits, if the new government going to appoint its own Chief Justice and all that. But before I get to that, there is a comment on Facebook that I want to bring to your attention from Nathan Bernard. He's asking, he said, Dennis Jar, are you a tribalism man? You guys are a tribalism people. So I don't know, Brother Nathan Bernard, what exactly are you speaking about? So please make it clear. You can put your comments more precisely. We are running out of time, and so we'll go to Councillor Williamson for his final comments.
Well, the justices of the Supreme Court, by law, are required to retire at the age of 70. They don't have term limits, but our Constitution is unique, and I want to read that aspect. It's found in Article 72B. It says the Chief Justice and Associate Justices and judges of subordinate court of record shall be retired at the age of 70. Now, here's the provided, however, that the justice or judge who has attained that age may continue in office for as long as be necessary to enable him to render judgment or perform any judicial duty in regards to proceedings entertained before him. That is, he must clear his docket.
Right.
So if he turns 70 in March and he got some unfinished docket, maybe he will allow him for a few more months to complete. But the age of 70 is the age limit for justices. But let me just thank you and joining Judge His Honor Melvin Johnson. I want to thank him for his patriotism, for his love for his country, and for his passion that he has for this country. And he is one of those that we will hope that will participate actively in the new Liberia. I also look forward to focus on Liberia being a pivotal factor in the new Liberia. Thank you for the invitation.
Thank you.
And Godspeed.
Thank you. Thank you so much for watching. Thank you, Anthony Williamson. Thank you, Judge Melvin Johnson. And thanks to all our viewers on television, on Facebook, listening to us on our TV International News. I want to thank to all our callers. I want to thank our studio manager right here. I want to thank our product engineer and producer. It's been a wonderful show. I want to thank everybody who has contributed. Focus on Liberia is brought to you every week Sunday at 7 p.m. So be sure to tune in. Next Sunday, we will be discussing the diaspora organizations, Liberian diaspora organization, and their impact on Liberians and Liberia. So please be sure to tune in with all your questions and comments. Always feel free to drop us a line, focus on Liberia at gmail.com or focus on Liberia marketing at gmail.com. Thanks again for watching. Goodbye and God bless.